Hi everyone, this is Brett Sankis, the Right Brain business lawyer and a business consultant. We're doing another video in our series about mastering business partnerships. In this video, we'll build on our last video, which was about escape clauses or exit clauses if you want to get out of a partnership agreement. Now, what we'll talk about today relates to exit clauses. It is particular provisions that will help you when you need to get out. So there's going to be four big ones we're going to talk about. They're things that you should consider putting into every single partnership agreement up front. So there's no substitute for a well-drafted custom agreement, the kind of thing that lawyers like myself do in the world. But if you're doing this DIY style, you're on a budget, and we're going to do another video talking about a good way to do that, by the way. But if you're doing it that way, and you're not really sure where you got this agreement or what it is, buyer beware, all that sort of stuff. But really, here's four big important things to take a look and see if they're in your agreement. The first is vesting. We've talked a little bit about it in other videos, but vesting is a concept that says you're going to own X% of this company, but not if you leave before a certain time. So it's a mechanism to protect other owners who stick around if an owner leaves early. So basically, this is very common in technology companies, in technology startups. Venture capitalists will make their technology, their portfolio companies, the companies they invest in, they will make the founders vest. And typical style is 4 years with a 1-year cliff, which means you earn your equity over the course of 4 years. You get it all, but you basically have to give it back if you leave early. The 1-year cliff means you get nothing for the first year. That's corporations, that's tech-style startups. In LLCs and other things, you can still do vesting. And it's an important thing to think about, which is just how committed are we each to this venture? If someone leaves early, it makes more sense it really makes a lot of sense in the startup world because you're really working very hard for a few years with the idea of growing this and selling it quickly. In more of a long-term lifestyle business, if I bring on a partner in my law practice, for example, vesting doesn't make as much sense. If someone leaves, you cash them out and they don't participate anymore. But in a business that you're growing quickly to sell, it makes a ton of sense. And we do that in LLCs and other things outside of tech startups. So if you've got something like that, you're coming together for a finite period of time to really try and grow a business quickly and big. If someone leaves and they walk away with all that equity, it hurts because you really need someone in their role working, producing, growing the business. So that's what vesting is. It comes in all sorts of different flavors, and it's not just technology startups. But again, the idea is you're going to earn your equity over time. You get it all on day one usually, but you got to give it back if you walk away early. And early tends to be 2 years, 3 years, 4 years. Not longer than that usually. So that's something very important to think about. Number two, restrictions on transferring your equity interest, your stock or LLC interest. So if you and I go into business together and the next day you decide you're tired of it and you sell your share to your brother, I might not know your brother. I don't necessarily want to be in business with your brother. So a couple of different things to think about here. One is there's a securities law issue here, and that's that you should have some. This is kind of more mine as my issue as the company to think about, but it's just we have an obligation to make sure that the equity we issue in a private transaction, which is what you'd be doing to issue startup equity, isn't just passed all over the place. So you'll see language in almost every agreement that talks about before you transfer your equity, you've got to get an opinion of counsel that says it's transferable and things like that. That's nuts and bolts stuff. I'm talking more about beyond that. So let's say it's just compliant. Can you transfer that stock or LLC interest to your brother? Well, I'm not probably going to want you to do that. There's some different ways to handle that issue. One is to say there's a flat-out restriction unless everyone else agrees. Another is a right of first refusal. That's very, very common, where you've got to, you want to transfer the stock, you come to me and you say, hey, my brother wants to buy my shares, I'm going to sell the shares, I'm going to sell them for $2 a share, do you want to buy the stock first? I'm giving you a right of first refusal. So, and that might be in favor of the other owners, it might be in favor of the company, which really is the other owners kind of, or it might be both. But the idea here being, before one of the owners can go and sell their interest to someone else, who the remaining owners don't know, the departing owner has to offer up the equity to the remaining owners. And that makes a lot of sense. It's very, very common. You'll also see restrictions on transfer pop up in situations, we call them involuntary transfers. There's situations in divorce or in death or in bankruptcy where the equity is transferred automatically. So if you're in business with me and I go and declare bankruptcy, bankruptcy trustee immediately has a lien on my things. So you would often see a provision in there that talks about that. Maybe gives the company or you or both a right to buy my equity at a certain value. So restrictions on transfer and involuntary transfers also come up in the divorce context. In community property states in particular, like in Texas where I am, a spouse absent a prenup or a postnup has an interest in in a business that their partner starts after they are married. So we would normally get a consent from a spouse saying, I understand I'm subject to some restrictions on transfer. And one of them would be if, again, you and I are in business together and you get divorced, that typically you would have the ability. The agreement would say you have the ability to go buy the interest back from your spouse. And a third is in the is in the death context. So it's very common that founders come to me and they really want to be able to give the interest in their company to their kids. And I appreciate that and I respect it. And I think it's some of the motivation to build a company is the idea of handing something off. But the practical reality is number one, there's problems with second and third generation businesses. That's number one. But number two is, again, you and I are getting into business together. You don't necessarily want to be in business with my son. Well, you definitely don't. He's 6 months old as of today. But you're in business with me. So in that context, if I were to pass away, there's a couple different things you could do. One is to say you would have a right, or the company would have a right, to automatically buy his shares back at fair value, however you determine that, and that's a topic for another day. But so my son would get something, but he'd be able to go invest it somewhere else, or you could strip out the voting rights. So he's got an interest in the business and ability to cash the checks, but not necessarily a seat at the table. And again, the reason for all of these is you don't want a bankruptcy trustee. You generally don't want a spouse who wasn't otherwise in the business. You don't want kids all of a sudden having a seat at the table. That can be really problematic because partnerships, for all the reasons we're talking about, are things that you should not get into lightly, and you don't want to be in with people that you're not sort of philosophically aligned with. So that's an important thing to think about. Another is non-competes in other opportunities. Are you going to be able to, you and your partners, do other things in the world? Are you going to be doing this 24/7? 100% of your time has to be in this business. Should you be able to have other side projects or other side businesses? How closely could those compete with this? I mean, it would be pretty rare to have an agreement that says the other partners can all go have competing ventures with the one that they're in. But you could. You would just have to be very clear about that, especially at a corporation or something where there's corporate law that would say there's duties, fiduciary duties, and something called corporate opportunity that would prevent you from doing that. So it's talking about what else can we do? What's the expectation? How much time are you giving? Can you be involved in other competing things while we're together or after? So you want to talk about what happens if we part ways. Can you immediately compete with the business? And there's a reason to say no, because you really don't want someone to exit the partnership and then try and steal all the customers and things. And so non-competes can come in flat out, you can't be in this business, or they could be what we call no solicits or no poach that say you can be in this business, but you can't come take our employees or customers. And you've probably heard, if you're in California, you've heard they're not enforceable. They can be enforceable in certain contexts, the sale of the business, and in some types of partnerships in the kind of context I'm talking about. In Texas, where I am, and in most states, these are enforceable if you draft them properly. So again, what is the expectation about other opportunities? What is the expectation about competing directly with the company during and after? And then a fourth thing to think about is who's going to own the important assets of the business. So mainly intellectual property. This is a very important one to think about going into it. Is there some intellectual property that one of the founders wants to be clear that is theirs, that they're going to hold, that they, if the business broke up, they would be able to take? Or is it all being contributed to the company? The vast majority of the time, we're contributing it all to the company. So you want documents that make it really, really clear that everything you own, everything you've worked on, the software you produce, the logo you drew, all that stuff gets contributed, and it's all the businesses. I do a decent amount of restaurant and bar work. Sometimes it comes up recipes and things like that. So it could be anything that people consider to be sort of proprietary intellectual property. It's what does the business own? Are you holding that back? Or would you have a right if it all fell apart or you left the business to go take that. So these are 4 really important things to think about. There's a lot of others, but there are 4 really important ones to think about. Take a look at your partner and founder agreement, see have you handled that stuff the way you should. If you haven't, give me a call. We can tighten that up. If you're just getting into the partnership, talk to your partners about how this stuff ought to work and be clear and intentional about it. So appreciate you joining me today. If you got any questions, reach out, drop a comment below the video. Thanks.